Versus State. You may proceed when ready.
Good morning, Your Honor. Eric Friday on behalf of the appellant Dale Norman. May it please the court, I'd like to reserve 5 minutes for rebuttal.
Okay, when you see the yellow light go on, you will be into your rebuttal time.
Yes, ma'am. Thank you. There are 3 certified questions before the court today, but they all come back to just one question. What do the Second Amendment and the Florida Constitution mean by a right to bear arms? Stated another way, is there a right to bear arms outside of the home, and can it be satisfied by the mere granting of a privilege or affirmative defenses, as it is currently limited in the state of Florida today? We ask this court to set aside any preconceptions that might be present and look at the reasoning of the U.S. Supreme Court in Heller and McDonald and their review of the history of the right to bear arms and how it's been understood since the founding. The state of Florida has already admitted that the right to bear arms extends beyond the home in its Kachalski brief. It has not refuted that position in this case, but has instead argued that by allowing a person to have an affirmative defense under Section 790.25 in certain limited circumstances, that the legislature has adequately protected and recognized a right. In recent case law, the Second Amendment has been repeatedly equated to the First. No court has ever held that the exercise of free speech may be limited to persons in their home, place of business, or certain enumerated statutory exceptions. No court has ever ruled that the First Amendment is an affirmative defense that a citizen must prove after they're arrested for engaging in a protected activity.
If we were to agree with your position, then would anyone be able to take a gun anywhere and there would be no restraint at all?
Your Honor, the Supreme Court made quite clear that certain sensitive place restrictions as passed by a legislature are allowed and are appropriate. If the Florida legislature chose to do so, they could absolutely restrict certain sensitive places, just as they've done in 790.06, the concealed carry licensing statute. In fact, the reason this statute was passed in the first place, and there's a law review article cited in the brief that dealt with this, was after the passage of 790.06 and 790.33, the Firearms Preemption Act, in 1987. One of the state attorneys, Janet Reno, realized that the restrictions set forth in 790.06 did not apply to people who were open carrying because there's no prohibition on open carry in Florida in 1987. The Florida legislature had a special session that year immediately following the regular, or a few months after the regular session, and when Ms. Reno brought that to the legislature's attention as an emergency measure, with no committee hearings, no opportunity for debate, and with no legislative history, the legislature passed the statute that we're here on today, 790.53.
Why does that make a difference, as long as they pass the bill?
They passed the bill, Your Honor, because of the specific concern that Judge May just raised, that being that somebody could carry a gun anywhere, and there were at that time no restricted places on open carry of firearms because all local ordinances that had been in place to prevent, for example, carry of openly carried firearms as opposed to concealed firearms in a courthouse had just been voided by the legislature's passage of preemption. So I was responding to Judge May's question by stating that the reason the statute was passed was specifically for that purpose, but it was passed for a limited purpose to do so in an emergency situation and should not have been allowed to stand beyond that session or that small opportunity to give the legislature a chance to more fully look at the issue and decide what places needed to be restricted for the purposes of open carry as sensitive places, consistent with the Supreme Court's later decision in Heller and McDonald.
It's been 30 years since that happened, and the legislature has chosen not to take any action at all on that.
Yes, Your Honor.
What should we derive from that?
Whether the legislature decided to take action again or not does not affect whether or not the statute is unconstitutional as it is currently written and enforced. And as it is currently written and enforced, there is no method of exercising the right to bear arms in the state of Florida. There is a method of exercising a privilege. And the Alabama Supreme Court in Reed, which was cited approvingly by the Supreme Court in both Heller and McDonald, pointed out that any statute which by transitory legislative policy can affect a right eliminates the right at all. And therefore in Alabama, while the Alabama Supreme Court was allowed to, while the Alabama Supreme Court allowed the legislature to have a ban on concealed carry, it refused to allow the legislature to have a ban on open carry. Your Honor, every court that has looked at this issue since Heller and McDonald, and including Heller and McDonald, has said the Second Amendment does not apply to concealed carry. Well, if we accept the reasoning of Heller and McDonald that there is a right to bear arms, and if we accept the reasoning of the Seventh Circuit in Moore v. Madigan and the Attorney General's own argument in the Kachalski case, that right to bear arms includes a right to bear arms outside of the home, and every court to rule on the issue has said that concealed carry is but a privilege, that only leaves one method of exercise of the right, Your Honor, and that is open carry.
What about the Peralta argument that there's an alternative outlet theory, that you can either ban open or ban concealed, but you can't ban both?
Your Honor, that's the argument that's been advanced by Alan Gura in both McDonald, Heller, and other cases. Our position is that the alternative outlet theory is not true to the history and the history of the Second Amendment and the rationale of the Supreme Court. For example, we recently cited a supplemental authority just this week, a law review article that discusses extensively that argument, in order to be true to what the Supreme Court's reasoning in Heller and McDonald was, must recognize that while the legislature is perfectly free to allow for concealed carry as an alternate method, allowing concealed carry as an alternative to the constitutionally protected right to open carry does not sufficiently protect the right. My analogy, Your Honor, would be if the city of West Palm Beach decided to ban free speech in the entire city limits except for some designated area that they set off by the courthouse, that would run afoul of the First Amendment. No court would ever uphold or suggest that a city can entirely ban the First Amendment except for some limited spot where they're going to allow it. And that is what I believe that the concealed carry does by allowing people to carry a firearm under certain situations. But again, Your Honor, it's only a privilege. It's an affirmative defense. A person is, under the recent Florida Supreme Court decision in Mackey, a person with a concealed carry firearm who is carrying a concealed weapon is subject to arrest, prosecution, and only has an affirmative defense that they must prove to the trial court that they had a concealed carry permit and therefore have an exception to the law.
I must tell you what jumped out at me from Heller, and I appreciate your citation to Heller, because I think you're correct when you suggest that probably is one of the preeminent cases out there. But really, what jumped out to me were these words: the Second Amendment is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. So in other words, legislature, if you want to make reasonable restrictions within the confines of the Second, do it. And then the legislature, to follow up on what Judge Klingensmith said, did. They have not sought to review that in the last 30 years. So I guess my question is, isn't this really your discussion here today, isn't this really more appropriate in Tallahassee with the legislature to say, listen, you can change this. The Second Amendment lets you change it. Why haven't you in 30 years?
Your Honor, in part, that issue is addressed by the vagueness argument in our brief, that the legislature attempted to modify it in some way recently in 2011, but did so in a way that made the statute not only unconstitutional, but also unconstitutionally vague in the way it can be applied. But, Your Honor, going back to the question of what Heller says in terms of reasonable restrictions, the Article 1, Section 8 is very interesting because it differs slightly from Article 1, Section 2. Article 1, Section 2, for example, allows the state to regulate or prohibit the owning of real property by illegal aliens in this state. However, in Article 1, Section 8, the framers of the Florida Constitution left out the word prohibit in regards to the right to bear arms and said only that the legislature could regulate the manner of bearing arms. And, Your Honors, up until 1987, every court in Florida, including the Supreme Court, held that the regulation of the manner to bear arms in Florida meant that the legislature could prohibit or license the concealed carry of arms and possibly could license the open carry of arms, but definitely could not ban the open carry of arms. And that comes to us from the Sutton case from 1868.
How would you write a statute that would be constitutional under your position in this case?
A statute that would be constitutional, Your Honor, might be one that said, for example, consistent with the legislature's right to regulate the manner of bearing arms, all handguns carried by a person must be holstered as opposed to stuck in the waistband. Or a rifle being carried while not engaged in hunting must be in a slung position. The legislatures can certainly make reasonable regulations as to how weapons are carried and where weapons are carried, such as prohibiting courthouses or schools within the guidelines set forth by the Heller Court, but to completely ban, and this goes back to the Davis case, to completely ban the possession and carry outside of the home of an entire or all classes of arms cannot withstand the strict scrutiny that is required when addressing a fundamental right as set forth in the Hillsborough Aviation case from the Florida Supreme Court.
So your position then is, the way the legislature has enacted this is that it's an all or nothing, and right now it's nothing.
Right now, I'm sorry, Your Honor.
I'm just gonna say, so you would be in agreement with something that had more, I guess, had certain restraints, but just not a total ban.
Correct, Your Honor. The idea, take Mr. Norman, for example. There is no doubt, 790.25 is absolutely clear, that if Mr. Norman was walking to a gun range, a place to go fishing, going camping, or going hunting, his conduct would have been perfectly lawful. But two police officers with no knowledge of whether or not he was going to any of those places executed what's commonly called a felony stop in an aggressive way, with cars approaching from both directions, pulling up on curbs, potentially endangering other pedestrians. Fortunately, there were none there at the time. All because a person who actually had been licensed by the legislature, in that case, to have that firearm, be present in that place with that firearm, had let it become visible.
Was there any evidence in the trial below that he was actually going to a shooting range or going camping or any of those things that you just mentioned?
No, Your Honor. There was no evidence presented in the trial court that he was engaged in any of those activities. But it comes back to the question, as also the second certified question by the lower court: are the defenses, or excuse me, are the exceptions set forth in 790.25 elements of the crime or affirmative defenses? Your Honors, 790.25 is a fascinating statute in my opinion. I have never seen another statute that states by its terms that it is a supplemental to rights that are already guaranteed, arguing I would think that it means it's a right, not a privilege or an exception or affirmative defense, and secondly says that it supersedes any statute in conflict therewith. So 790.25 by its terms says if you want to create a statute in conflict with 790.25, you're going to have to come back and amend 790.25 to take out that supremacy exception, or arguably make explicit in the new statute that notwithstanding the provision of 790.25 that it's supreme, this legislature is passing a law that we are expressly placing in conflict as a more recent statute.
I mean, you raise an interesting point, which is that your client could have, if the gun had been concealed, he would have been okay. And yet, no one would have known it was there, but now knowing that it's there, somehow that's worse.
You know, that's an interesting point, because actually the Florida Sheriff's Association, during the legislative debate over the passage of 790.06, which eventually led the legislature to have to act quickly on 790.53, the Florida Sheriff's Association repeatedly argued during the committee hearings on that statute that they wanted to continue the open carrying of arms, and they did not want to they did not want to allow for the concealed carry because it was easier for the officers to know who was carrying arms. Furthermore, there's an FBI study that's cited in our brief where the FBI concluded criminals don't carry arms openly. And Your Honors, I have to take you back to a point that I've made repeatedly, and that is we here in Florida are one of 5 states that absolutely prohibits the possession of arms outside of the home openly, with a few limited exceptions. The other states are South Carolina, Illinois, New York, and California. And California only did so recently, and in fact, recently, because of enacting that, got the decision they got in Peruta under the alternate outlet theory, which, again, we don't agree necessarily that the alternate outlet theory is correct. we would subscribe to the theory that the Second Amendment means what it says. Every court to rule on the Second Amendment has said it can restrict, that you can restrict the concealed carry of arms, but none have allowed restrictions on the open carry of arms. There's just not a case out there that allows it. And especially not any case that is close in time to the enactment of the Second Amendment or close in time to the enactment of the 14th Amendment due process clause, which incorporated the Second Amendment to the states.
What were those others, you said California, New York, Illinois?
California, New York, Illinois, South Carolina, and Florida.
That's interesting. It sounds like South Carolina and Florida are kind of the outliers on the other group.
Well, Your Honor, Judge Buford in the Watson v. Stone case in 1941 explained why Florida, and it's also why South Carolina, and it's also why old statutes in Alabama and Georgia existed. They existed because they were a method of regulating and prohibiting the right to bear arms to recently freed slaves. Judge Buford in Watson v. Stone even commented that the restriction at issue in that case, which is a precursor to our current statute, had never been applied to a white man, because everyone knew that if it were to be so applied, it would be held unconstitutional, and that was a concurring opinion in the Watson case. Your Honors, both Heller and McDonald extensively discussed this issue in their reasoning that the history of the Second Amendment, the history of the regulation of firearms has been to regulate against certain classes from having firearms. And Florida cannot escape the lineage of that's what we've done. Arguably, this statute being of more recent vintage was not such a decision, but the reason we have licensing in Florida at all is for that very reason. Thank you.
Morning.
May it please the court, Cynthia Commerce on behalf of the state. I would like to point out that in Heller, they never addressed the right to carry arms outside of the home. They discussed that there's a fundamental right to possess handguns in defense of the home. And they did discuss also the fact that the Second Amendment right is not unlimited, and that, as you had pointed out, it is not the right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. And in saying that, they explicitly approved certain gun regulations, saying that their list was not exhaustive, meaning that they pointed out that you can regulate the possession of firearms by felons, by the mentally ill, forbidding the carrying of firearms in sensitive places, and imposing conditions and qualifications on the commercial sale of arms. In Florida, you can lawfully carry a concealed firearm if you have a license. And although there is not a right, or you cannot openly carry a weapon, there are numerous exceptions in 790.25. 790.25 does have like a supremacy clause and a conflicts clause, which basically says if a statute conflicts with this, meaning 790.053, that it supersedes. And if you look at those exceptions, there are many times when you can carry a weapon openly in Florida. So this is not an absolute ban in a sense, because you could qualify if you're engaged in fishing, camping, or lawful hunting, going to, returning from, you can expose your weapon. If you're firing weapons for testing or target practice, that you can expose it. If they name numerous people, the military, the National Guard, the Florida Defense,
Can I just ask you this? If someone has a license to carry a concealed weapon, how is it more dangerous for them to expose the weapon? In other words, it seems to me that it's more, that getting a license to have a concealed weapon gives you a special privilege to be able to do that. How is it worse to have it exposed?
if it's exposed, first of all, it's apparent to everybody that you have this weapon. If you're,
Wouldn't you rather know that than not to know that the person's carrying a weapon?
in this case, for instance, I mean, the fact that there was a 911 call shows that a concerned citizen was actually worried about this person carrying the firearm openly down the road. So that shows.
Should we be concerned about somebody's concern about an exercise of a right?
Well, what the other thing is that there is a public safety concern and the interest in preventing crime prevention. So if you have somebody who's walking down the street openly carrying a weapon and it's in their holster, What's to prevent somebody who's a criminal or a mentally ill person from coming over, grabbing that gun and using it either on the person carrying it or somebody in close proximity? I mean, we're dealing with firearms. They are lethal by nature, and they are lethal for great distances. So obviously they instill fear in people when they are seen, and there's a fear that they could go off.
I can understand, I understand your point. I guess my question is, though, this person's already been licensed to be able to conceal the weapon and walk around with it. I can see the point you're making, more so if the person didn't have a concealed weapons license. So you have somebody that's not been licensed at all walking around with a weapon. I think the point or the fear that you're expressing makes more sense then. But if this person has gone through the process of being able to carry it concealed, shouldn't that maybe be an exception to this? That if you have a concealed weapons permit, that is also an exception, because that person's already licensed to walk around with it when nobody knows.
It's not an exception.
Well, I know it's not, but it makes more sense to me. I mean, if you're licensed to walk around with a gun and not let anybody know it, I don't know how letting people know it makes it worse.
Well, if it's concealed, you know it's there, you can access it, you've been trained or gone through the courses or whatever, and you can still use it in your self-defense. But if it's open, anybody can access it. What if a child grabbed it? I mean, you don't know.
So you think that the basis for the statute is that by having a weapon exposed allows other people to get access to it, and that's
Yes.
the biggest issue?
Well, public safety and crime prevention. It reduces the injury and death by firearms. It reduces the incidence of unlawful public shootings.
What does?
By keeping it concealed.
What studies have said that?
That's just, to me, common sense, because if
Well,
it's concealed and you don't know it's there, how can you take it from somebody and then use it? If it's openly displayed, you know it's there and it can be taken and used in any manner.
Have there ever been any studies that show that the open carry of weapons either increases or reduces the risk of the type of harm that you just described?
I don't know the studies. I'm not aware of any studies, but that's just, to me, common sense. And as I said, in Florida, this is not an absolute ban to carry a weapon in defense of yourself. You can carry a concealed weapon. They're saying, and also even with the prohibition on carrying openly a weapon, there are so many exceptions in 790.25 that it's not an absolute ban either. So this is a reasonable regulation to further a legitimate government interest.
Is a right to bear a firearm, is that a fundamental right?
To bear and carry a firearm, I would say yes, is a fundamental right.
So then how should we review Chapter 790 in terms of its restriction on what you have admitted is a fundamental right? Should we look at it under a rational basis test or a strict scrutiny analysis?
The state contends that it's a rational basis, but even under strict scrutiny, it would comply. What happened here is we are not regulating, we're not saying you can't carry an arm outside your home. We are regulating the manner that you carry it, which is explicitly provided for in our Constitution, that the legislature can regulate the manner it is carried. You can carry it openly or concealed.
But you need to have a license to carry it concealed, so isn't it in the realm of not so much a fundamental right, but almost a permissive use?
Well, if you look at that statute, it says you shall issue a license. And then when they are precluded, it's when things that have been addressed in Heller, for instance, if you're a felon or you're mentally incompetent, then you don't get a permit. But so that is constitutionally permissible reasons. But it does say you shall issue a license in that case. So Florida has strongly found that a concealed carry permit is the way to go.
But if you can only do it by means of having a license, doesn't that become a privilege, as your opposition suggests?
No, Heller says that you can place reasonable restrictions on the right to carry outside the home. That is a reasonable restriction. The state has an interest in making sure that people that are mentally ill or that are convicted felons or abusive to their spouses or whatever shouldn't be carrying a firearm. it's not an out ban to everybody. There is a reasonable link to it that's permissible under the Constitution. And I would say even under, if you wanted to apply the strictest scrutiny, which has never been done, I mean, nobody's ever applied strict scrutiny to a Second Amendment challenge, that you do have a compelling state interest, and this is the least intrusive means possible to regulate it. We have, you can conceal carry in defense of yourself. And although you can't open carry, there are numerous exceptions. As I said, there's like 16 actual listed exceptions in 790.25, and within those exceptions, it's broadly worded. There are lots of people that qualify that can openly carry their weapons.
Well, let's take your common sense argument that you used a few minutes ago. Wouldn't it be more common sense in a public safety analysis that people are less likely to attack somebody who's openly carrying a weapon than attacking somebody who they don't know has a weapon? So from a common sense standpoint, wouldn't it be safer to open carry?
I still think that there is still the possibility, say you're standing in line at the checkout and you're openly carrying a weapon and you've got groceries in your hand. What's to prevent the person behind you grabbing their gun, using it on you and anybody that's within close proximity? I mean, maybe a criminal's not going to rob you, but it doesn't mean that your gun cannot be used in an unlawful purpose. And if you have it concealed, you know it's there, you can still access it, you can still defend yourself, but other people don't know. And that way, there's not a risk of this happening. So I say that's a legitimate purpose because it's out of public safety concerns that you're limiting this.
I'm just looking at the statute itself, and I see that after 97, there were 2 other changes to the statute in 2006. Do you know what those were?
I know initially it was like lumped together, and then it was broken apart into subsections. And then, of course, in 2011, that was the amendment where it's not a violation if you have a license to conceal a firearm. It's concealed and it's briefly and openly displayed unless it's intentionally displayed in an angry or threatening manner.
How do you respond to that about the as we learned in law school, the void for vagueness argument about a brief type of exposure?
Well, in this case, we never get to that point. I mean, I will address that also, but I would say that as applied to this particular defendant, he does not have standing to raise that challenge. If he did have standing, just because there are different ways to, common sense and the dictionary common understanding of these words, brief and openly, would put anybody on notice what is prohibited. And also you can look at the opposite of concealed, and what you have here is that, is it concealed? Is the ordinary person able to observe this as a gun? So I would argue that this is not void for vagueness. It is a person of ordinary intelligence would understand exactly what is prohibited. And just because there are different interpretations or ways to construe that, it doesn't make it vague. Does anybody else have any questions?
Well, let me ask you about, let's go back to the issue I was talking to you about before. How many other states have open carry laws allowing that to happen?
I honestly don't know.
Or would you agree with your opposition that only 5 states prohibit it?
Prohibit open carry?
Yes. Would you agree with that?
I cannot say one way or the other.
Okay, would you agree that the majority of states permit open carry?
I would say the majority of states permit concealed carry, that they usually do, that they prefer, that's the preferred method is to conceal your weapon.
So what's your position on whether the majority of states permit open carry?
There is no constitutional right to openly carry a
I
weapon.
didn't ask that question. My question is, do most states permit open carry in their laws?
I honestly don't know, to be able to answer that. But I would also point out that we are talking about the manner of carry here. We are not prohibiting the carrying of a weapon in defense of yourself. This is the manner, which we are explicitly, the Florida Constitution permits you to the legislature to regulate the manner of bearing arms. Heller permits you to do this. A Supreme Court case, Rensler, says, although the right to bear arms shall not be impinged upon, the legislature nevertheless is not so restricted that the body may not regulate the way in which the arms may be carried. And that it's not an absolute right. And the people, through their legislature, can enact valid police regulations to promote the health, morals, and safety and general welfare of the people. And that's what I contend exactly what has happened in this case.
What about your opponent's suggestion that that long litany of exceptions are elements that the state is required to prove and not affirmative defenses?
You have the Supreme Court case Mackey. It's a Florida 2013 case that came out, and also this court's case in Watt, which clearly say, in looking at the concealed carry weapons statute 790.01, that the licensure is affirmative defense. And in that case, what you have is you have the enactment clause in the first section, and in the third section it talks about licensure. What that is based on the location. It's not in the first section, it's in the third section. Here we have a completely separate statute. So based on the Supreme Court's, and they said that's very much understood based on the location of where it's located, that it can be interpreted as an affirmative defense. So that would be Mackey and Watt. Is there any other questions?
Thank you.
Thank you. We'd ask if you affirm the denial of the motions to dismiss.
Thank you. You have a little over 3 minutes left.
Thank you, Your Honor. The state argues that Heller never addressed the right to carry outside the home. What Heller said is that you have a right to keep and bear arms in case of confrontation. Judge Posner in the Seventh Circuit in Moore v. Madigan made a very clear analysis that if you have a right to bear arms in case of confrontation, that right is certainly equal outside the home as it is inside the home. The Attorney General of Florida made the exact same argument in the state of Florida's brief to the U.S. Supreme Court seeking certiorari in Kachowski. When dealing with fundamental rights and applying strict scrutiny, the state does not get to come to an appellate court and invent a justification for the statute being passed. The justification for the statute is set forth in the limited legislative history and, more importantly, in the law review article, or law review note that was cited in the brief that discusses how, contemporaneously discusses how this ordinance or how the statute came to be.
If we were to agree with you, how would our opinion be written?
Your Honor, I think the way the opinion would be written is that every court to consider the issue has ruled that concealed carry is a privilege, not a right, that the Florida legislature has written the concealed carry statute as a privilege, not a right, that the third DCA in the Crane case held that the license is a privilege, not a right, and that every one of the 19th century courts that Heller quotes all rule that the right protected by the Second Amendment is the right to openly carry a firearm. Now, I can certainly understand that the court would be concerned, especially after my presentation that, and my position that declaring 790-053 unconstitutional would necessarily open back up, for at least a time, the Pandora's box that State Attorney Reno was concerned about when 790-053 was enacted. Judge Posner in the Seventh Circuit had the same issue when he overturned all of Illinois' laws regarding concealed carry and open carry. Judge Posner's solution was a stay. I've never suggested a timeline to an appellate court before for issuing a ruling. However, in this case, we do have a legislative session coming up, and were this court to issue a ruling prior to the legislative session, it would give the legislature a chance to take the court's ruling, preferably that 790-053 is invalid to the extent that it prohibits entirely the right to open carry arms, and would give the legislature a chance to, by the end of its legislative session, or 90 days, whichever comes later, a chance to hold a special session if necessary, but to have a hearing and to have an opportunity to pass reasonable restrictions, such as expanding perhaps the list of places in 79006 to, or some of the places in 79006 to the open carry of firearms as well.
Now, you just mentioned the Moore case. Did Judge Posner say in Moore that open carry was a constitutional right?
No, Your Honor, Judge Posner did not get into open carry because the open carry statute at issue, I apologize, I misspoke. The open carry statute in Illinois was not at issue in Moore v. Madigan. Moore v. Madigan was a question of there was no right to carry concealed, and
I understand, but you made a comment that open carry was addressed in that case.
I
and-
misspoke, Your Honor, I apologize. Getting back to the history of the law in Florida, in 1868, the Sutton case said that hereafter, pointed out that the statute said that hereafter it shall be not be lawful for any person in the state to carry arms of any kind secretly on or about their person, provided that this law shall not be so construed as to prevent any person from carrying arms openly outside of all of their clothes. Your Honors, 1868 was the year of our first Constitution post-military government after Reconstruction. So at the same time that the framers of the Florida Constitution are passing a law that says there's a right to bear arms in Florida, they also passed a statute that said hereafter it shall not be lawful for concealed arms, but shall not be construed to prevent a person from carrying arms openly outside of all their clothes. It was only after the passage of an enactment of the 14th Amendment a few years later that the Florida Constitution was changed to provide for a regulation of the manner of bearing arms.
Okay, you're over your time. If you could sum up, please.
Thank you, Your Honor. Your Honor, the Attorney General has briefed this issue twice. Once in the brief for certiorari to Kachalski, where she had an unfettered opportunity to deliver an analysis on what the right to bear arms means in the state of Florida. And in this case, where she has a constitutional obligation as Attorney General to defend enactments of the legislature against any attack and to defend cases coming out of the state attorney's office on appeal. This court should place more weight on what the Attorney General says when she has an unfettered right to make her own analysis versus what she says when she's acting under her constitutional obligation to defend what is clearly an unconstitutional statute that was passed in haste. We have a right to bear arms in Florida, not a privilege.
Thank you very much. We appreciate all your time this morning. Court will be in recess until next week.
Go outside and get a picture of everybody together. That'd be the easiest way to do it from the courthouse.
Yeah, sure. Thanks for listening. I'm trying to meet you earlier. I'm everybody. So nice to meet you.